Okay, you should be unmuted and ready to roll.
Hey, hi, good evening, everybody. My name is Donna Raftery. I am Chair of Community Board Two's SLA Committee. Welcome to our August meeting. We are waiting for one more person for quorum, but I thought it's getting late. So I thought I'd just start this along. Also on the committee, we have Dr. Shirley Smith, Lois Backrell, and Kate Boston. Okay, so this is how it works. Everybody in the room, make sure you've signed in. If you're a member of the public and wish to speak on an application, please fill out a speaker card in the back and hand it to me up here. Then we are not taking the items in the order that they are on the agenda. The agendas are in the back. I'll call the applicant up, come up to the very well sanitized podium. There's two microphones, make sure they're on. You have to use the microphone, so you can raise and lower the stand. You can take both microphones out, but you need to use the microphone. The applicant will present their application to the committee. The committee will ask any questions that they have, and then we will go, once we finished and the applicants responded, we will go back to the public. If there's any public members here that wish to speak, once we've heard from everybody from the public, we'll let the applicant respond. And that's it. We ask that everybody speak respectfully to each other and about the applications. And again, use the microphone. Our September meetings are going to be after Labor Day. So SLA1 was scheduled before Labor Day. It is not. It's the day after Labor Day. So just make a note of that. And item D2, Park at Kim's LLC was laid over just before the meeting. We are waiving the appearance of the C1 Max New York Union Square LLC at 841 Broadway, E1 Little Lucky's at 224 Lafayette Street, E2 Bleecker Hospitality at 169 Bleecker, E3 24 Fifth Avenue LLC doing business at Claudette at 24 Fifth Avenue, and E4 Center for Goods LLC at 53 Howard. Some of them are re-notifications, some of them are just the sidewalk that we have stipulations for at prior sidewalk or prior agreements. So that's that. Okay, the first application we're going to call is B1 Blank Forms Inc., 151 Lafayette Street. Is somebody here on that one?
Yes.
Great. Come on up.
So.
Okay. Is anything any different? So I don't need, I'll take it.
No, sorry.
Okay. Yeah. Okay.
All right, my name is Lawrence Kump. I'm the Artistic and Executive Director of Blank Forms. We are a nonprofit organization currently based in Brooklyn, moving to Lafayette Street below Grand. And we, for experimental music, run a publishing company and work with visual artists as well. And so we are applying for a beer and wine license for an auxiliary cafe in the space that we're opening.
And the hours are?
The hours are Monday through Saturday, 5 to midnight.
Okay, the access to the space is?
Access is 151 Lafayette.
Okay, and that's by the elevator and
Yeah, and
It's there.
stairs, but it's sort of far up, so
with the elevator.
elevator.
Okay, and then there's live music,
Mhm.
which is the performances,
Yes,
and you sell tickets for those.
exactly.
Okay, I did look at your Brooklyn website.
Yeah, it's-
So do you have, I mean, there's spaces here for all the music and people.
Yeah,
But
plenty of
you
space.
Sell out a lot, so we're all
Yeah.
sold out. Okay, I think, that was it for my questions. Does anybody on the committee have anything? No? Is there anybody here from the public on this one? We send you stipulations that I'm sure you're trying to run over with it and, yeah, we've got all of that. Okay, great,
Thank you.
Okay. Okay, the next application is going to be C3 Nico Grand LLC doing business as Cato Hibachi Sushi Bar at 194 Grand Street. Did you bring printouts of your application? Okay.
Hello. Is the questionnaire and the liquor license application. You know,
Is anything any different?
no,
Okay.
hi, I'm Matthew Leone for the applicant, and this is Ken Lynn, who's the owner operator. This is an application for an on-premises liquor license. Mr. Lynn will be operating full-service hibachi restaurant with a sushi bar. The hours or the proposed hours are 11 a.m. to midnight, 7 days a week. The restaurant occupies the ground floor and cellar level. The ground floor is 8 tables with 40 seats. There's a bar with 10 seats, and part of the bar is the sushi bar area, and that's an additional 7 seats. And then the lower level is where the hibachi tables are, the hibachi area. There are 6 large tables that could seat up to 98 people. So I think the total occupancy is 155. There's recorded background music only. There's no live music, no DJs, no dancing. There's no outdoor use. There's no promoters. The premises is located adjacent to a hotel. If the premises was licensed previously as a hometown hot pot and barbecue, I think roughly from around 2015 until May of 2026. This is Mr. Lynn's first ownership of restaurant and liquor license. However, he's been the general manager at a similar restaurant in Queens called Nico Hibachi on Union Turnpike in Fresh Meadows. So he does have a lot of experience operating, running the business, just that he hasn't owned it before. And he'll be there 7 days a week initially until he can, well, it's really up and running, and then he'll hire a manager and work there 6 days a week. So,
Okay,
and he's here if you have any.
okay, there's 3 TVs.
Oh, yeah, they think they're gonna have 3 TVs, 2 behind the main bar
Huh.
and 1 behind the sushi
And
bar.
how big are they about? Just because I put in the
Sure.
stipulations, 55 inches or? 55. Is the sound on? Do you keep the sound on or is
Yes,
the
I'm done, yeah.
sound on? Okay,
I think only 2,
Oh,
no,
two?
2 which is my,
Oh, okay.
there's only 2 in the.
two in the bar, okay. Okay, and background music is no outside. Okay. I think that's it. Well, my questions, does anybody on the committee have anything?
I did,
Go ahead.
hi, regarding your TVs, and you want to have the sound on, why do you need the sound on?
No, I mean, the sound for the TV, not the sound on.
No, no.
No sound.
Keep it on, okay, so.
So you have basically maybe closed caption or,
The type on the, the type that goes across the bottom that says.
Yeah, he could do that, the TV doesn't have to have.
Yeah.
If there's gonna be music,
Yeah,
and what's gonna be on the TV?
maybe like the sports channel like that,
Okay,
Yeah.
thank you.
Yeah.
No sound, sports,
sports channel, yeah.
captions.
Okay, okay. Okay. Anybody else? Anybody here from the public? Okay, so we send you a are you familiar with our stipulations? I don't, we send a stipulation form, it just lists out the hours, it says you're gonna operate as a hibachi and sushi restaurant, you're not gonna be a lounge tavern or a sports bar. There's no outdoor background music. You'll close all doors at all times, there's no operable doors or windows other than entering, there's no French doors or anything like that, and no unlimited drinks and no bottles. Okay. Dr. Smith, did you have something?
Yes, you were the manager for how long in the restaurant?
15 years,
15,
yeah,
the same restaurant?
no, the 2 different restaurants.
Thanks.
Okay.
Okay.
Thank
All right, thanks a lot.
Okay,
Thank you.
thank you. Good luck.
Thank you.
Okay, the next application is going to be C2 H&M Restaurant Inc. doing business as La Vita.
Hello, everyone.
Hi.
So this is an on-premise liquor license application for H&M Restaurant.
First state your name.
Oh, I'm sorry.
That's
My
all
name is Robert Hull with Michael Kelly Inc. here with the owners Amir. This is an on-premise liquor license application for H&M Restaurant Inc., DBA La Vita, located at 163 Mulberry Street between Grand and Broome Street. We've been open and operating since 2013 with a restaurant and wine license. We've had no SLA violations during this period. We are a full-service Italian restaurant with 21 tables, 42 seats, and a service bar. Our hours of operation are 11:30 a.m., 10 p.m., 7 days a week. We have one TV and background music. We have an approved Roadway cafe and did file a sidewalk cafe. We're still going through the process with that. The owner is an on-site manager when he's not there. We have another gentleman, Ronaldo Beckraj, who is a manager. He's been employed there for 11 years. The only changes to our premises will be the upgrade to the full liquor license. We'll have a few cocktails, but mostly aperitifs such as Sambuca. We get a lot of requests for these and a few other drinks for dinner. We've handed in 38 signatures of support from our block, including 12 from our building.
Okay. So you close at 10 o'clock, not 11 o'clock? Yeah,
Yeah.
that's what you want.
Yeah.
Okay.
I want to say 11.
Yeah, I
I
mean, the outdoor closes at 11, so. I mean,
We'll take 11 just for,
Take-
you know, holiday.
take 11, take 11, you
So
know,
let's-
take 11, but, I mean, 11 is totally reasonable. Okay, so when this application came before the board initially in 2012, there's an enclosed sidewalk cafe, I believe, is it, that sticks out to the sidewalk on a platform? I think it's the area in the drawing, it says railing.
Yeah, right there.
And so that's, if that's not, I mean, there wasn't a recent 2026 picture on Google Maps and I didn't walk over, but it was there a couple of years ago still. It's like enclosed thing that's not supposed to be enclosed.
Okay.
And so your diagram isn't showing seating there, but that shouldn't be part of the licensed premises. And there shouldn't be chairs there, and the 21 pictures showed chairs there.
Okay.
But it's not on the enclosed sidewalk cafe list, so it wasn't done, and this was the issue back in 2012, which is why the community board actually did not approve the application, not because they had a problem with the application itself, but because there was the enclosed sidewalk cafe.
Okay. Can you guys do that? Okay, take it out. We'll
Take it out, okay. Okay, does anybody from the committee have any, it's a class change. Anybody have anything to you? Is there anybody from the public here on this application? Okay, okay, good. Thank you.
Thank you so much. Okay.
Okay. Okay, okay. Then, okay, so the next one is going to be A1357 West Broadway LLC doing business as Pro Box. There's nothing any different.
No, just we clarified. the
Welcome, Terry.
To match the stipulation that we originally signed. For some reason, there was a discrepancy.
But you did what?
So the hours are 12 to 12 is the original stipulation.
Okay.
We corrected the hours,
Okay.
because I believe that was a mistake that was made last time. Basically, this is an application for an alteration to add a bar to the second floor of the premise. There are no changes in hours, method of operation, and is just adding the bar on the second floor.
Okay, so Terry, we had asked them last month to come back for a change in method of operation.
Yes.
And the reason we did that is because the stipulations currently say there is a rotating chef. It's a full service restaurant and all these things. The website shows it's not what they described to us last month. It's not that this is I just want to have it clean.
Yeah.
You know what I'm saying? So it's not a problem at all. I just don't think that the way they're operating, I don't think it's the same as our stipulations. There's no full service restaurant on the website. There's no full menu on the website. It's
This is just.
it's a salon, and then it's a cocktail lounge, and then it's another lounge. So it's not again, it's not a problem, but it's just.
So just to clarify, it is a full service restaurant. The concept, they have different concepts on the different floors with the rotating shifts. The menu you have here before you is the menu that they use. The concept that was on the third floor is now on every floor because that's the one that worked. As far as the different type of foods they were having. So the food menu that you see there is what they're using. Now, if what you're saying is you don't think that meets the requirements for a full service restaurant, that would be different. But the menu in the back that they attach to the back of the, which is really, you have to look at the first page, the rest of it is all the alcohol and everything else that they have.
I don't see the menu, quite frankly, all I see is the menus.
Yes.
Menu?
Sorry.
Under-
These are the
Yeah,
items that
I
they-
don't, I mean.
So
it's just-
if what you're saying is that you don't think that meets the requirements for a full service restaurant, then I would. If you're gonna take that position, then I would say we would have to come back with a separate application and change the method of operation.
What Donna said, it doesn't match this. She didn't say,
Right.
right?
Well, no, the full, yeah, but that's the crux.
I mean,
The stipulation says full service restaurant.
And say that it's
And if we have seen the.
Yeah, I'm
yeah, no, I mean, I get that the plan didn't work in switches, but it says that it's rotating chefs,
Right, they don't have rotating.
guest chefs,
I don't have.
create their own multi-course prefix menu, then.
So I have to send a new notification, come back next month for a change in method of operation.
Mm.
And this is the alteration to add the bar, the second floor. Or you can wait and do them all at once. I have to come back one way or the other.
Because we didn't get any 30-day notice, I hate that, we have to do that.
So,
Yeah. So why don't we just come back next month and do both things. And just change that so that we get this, because there were so many problems before, I don't wanna have a problem. Right.
And, yeah, and the reason is that there's the track history going back, we'd rather just have this all right, all correct.
No,
You know, clean,
I completely
Yeah.
understand, I have no problem with it. Just so everybody was clear, they do have food, people come and sit
Right.
down, they order
Okay.
everything else, that's the menu they use.
Okay,
They used to have 3 concepts on
right,
each
right,
floor.
and now
trying
it's
to
the
make
same
something
thing.
work. Now it's just one.
Okay, and if the 12:30 is what they're doing, just get it clean. Cause,
Yeah.
'cause it says 12:30 online, so if that's what you want to do, at least put that in the application instead of, not doing whatever.
So what we'll do is tomorrow we'll send out a notification.
Thank you.
Method of operation
Sorry.
Change, no, it's not at all.
That's
And
it.
then we'll come back on both.
Perfect. Okay, good, thank you.
Oh, grilled cheese. Grilled cheese.
Okay,
Corn cheese. So this is in layer.
okay, so the next one is going to be A3 Ambleside Partners LLC doing business as Gospel, 281 Lafayette Street. Is there anything any different? Yeah.
Yeah.
Yesterday, what you got?
Yesterday was still, I don't know if everybody.
I got yesterday.
So. Whenever you're ready.
Go ahead.
So. We're here on this, there are 2 applications, just so everybody's clear on, okay? The alteration application is adding an additional bar, a second floor, and adding additional space to the second floor. The method of operation change is adding a DJ or the ability to have a DJ on certain events and to change the operation to a tavern which has food, but not the full food menu, which was the issue I raised in the previous application. The applicant provided to you a very, very detailed application, a detailed agreement with the community board.
I just want to clarify that.
With the community, at the community.
Right.
Right, and then also a stipulation that they also entered into with the members of the community on the block session. That is not the community board, we're here to speak to you tonight, but the residents directly around the premises have entered into these 2 agreements, which we are willing to make as conditions to your stipulation that you create, if you amend this to your stipulation, whichever way you choose to do it. But these 2 documents will go to the SLA as what our agreement is with regard to the change in the license.
Okay. So. For the alteration,
Yes,
how much space and how many seats are they on it?
see, the space is approximately 1,500 square feet, I believe. There's
On the first floor, correct?
no, yeah, space on the first floor, yeah.
Yeah, I think it's probably about 40 seats. 40 seats, yeah, and it's, yeah.
The first floor, so that's.
So in your diagram, that would be the area to the right and then behind the.
Over here.
Yes, yeah.
And then where it says kitchen, is that kitchen? That's,
Let's have a look.
yeah,
This is on, sorry.
is a kitchen going there? Is going there?
Yeah.
Okay, and this is the part that you currently have?
Yeah.
Okay,
That's the.
okay, so. All right, and downstairs, are you adding? Seats?
No.
No,
Okay, because when I. It says the maximum occupancy is 289 persons and it's currently 183. So that's one reason I'm asking. And the other reason I'm asking. So this,
there are no changes to the basement. The only changes are what we've added in the square footage space. That obviously he's got 40 seats, but obviously occupancy is more than his 40 seats, but that could be one of the reasons that occupancy has gone up to that.
okay, so. Just give me 1 second, 66. 70, 80. So it used to have 80, it used to have like 90 seats. That's what it used to have. According to our thing, so now it'll have
130.
120, 100. Yeah. 120, okay, so it's in conditions of. All right. So the method of operation is adding the DJs. Live music,
Then could the options have live music, but that's not something that gives the closest ones.
so the application is to add DJs.
Yes.
The application is to add DJs and live music?
Yes.
Okay. So. Then I'm going to say, Terry, which is what I said to them, but just so you hear it. All these stipulations that are, like, a lot of these are in here, do the soundproofing, no vibrations, won't be heard in people. It's everything that was gone through in 2016 and everything that was supposed to happen then. And so I don't understand what the difference is, because now, I mean, this is like, okay, so if you add the DJs onto the license and everything that's been happening for the past 10 years inappropriately is now, okay, but what's been happening, I'm just going to say, has caused a nightmare. So it's a nightmare on the street, it's caused a nightmare, not just, I just want to just say one thing and then you can go ahead. It's not just the people that live in these two buildings. We have letters from other people that aren't represented in this agreement. And then you have all the traffic on the street of any poor person who's going up Lafayette Street. Who is impacted by this. I mean, they're sitting in one lane of traffic, and once they make Lafayette Street one lane, as they're proposing to do, I don't know what's gonna happen. So it's not just the nice people in these two buildings, it's a whole bunch of people, so, like.
Let me start with the sound issue. The sound issue over the last 2 years, and was it? Let me spend the time. Almost $1 million in soundproofing to make sure that it's shell, no noise is getting out of the premises. I don't know of any violations for sound coming out of the premises. When it comes to the security on the street, they have security on the street. The only thing I can tell you is if you want additional stipulations that they'll station somebody outside as security, move traffic along and everything else. That's
They're already doing that. And that's causing a nightmare. I mean, we have videos sent all the time to us of the traffic people and the big signs out on the street pulling everybody over.
you know what, I'll address that when whatever opposition shows up, says anything, because
Well, I'm just gonna say, Terry, this is that now, the opposition has been here for all the other meetings. I mean, we've heard this a bunch of times and the opposition has been here. So I'm just going to say that.
That's fine.
Can I just? Hello,
Yeah,
is that working?
yes,
Yeah.
you might want to just, you might.
Hang on, it might be, it might need a little switch, excuse me.
Yeah, it was this one. Yeah.
It's okay.
Hello.
I understand you. There it is, right there. Just that is.
What, I'm just gonna clarify first before I say anything, what was the opposition we heard, the last two meetings? Cause I can't remember what the opposition was.
I think you can go back and watch them, quite frankly, we sat here for hours on it, but I mean, people, we have letters and letters from people, the people that you've been making these agreements with have been complaining for years, that's why that I think they're doing this, because they've been trying to get results from the liquor authority, from the police department and from everybody else, and we have letters into the community board for a very long time
I
on
understand,
that.
I understand that. Rick. I don't think it's fair to say that the reason that everybody worked so hard on this agreement and went to this agreement is that's the reason. But
So the reason was because the neighbors said the liquor authority had failed. And they had failed to enforce the regulations, and that's why they felt compelled that they had to enter an agreement. Because they had no other recourse, and that was testimony that was given at the last meeting. That's what they said.
I don't know who said that, or what member of what association said that, or what member of what building said that, okay? I also know that they haven't gotten any summonses with regard to, I've listened, so just listen, from my standpoint, okay, from my standpoint, and being fair, one side to the other. Okay, there aren't noise violations from DEP or DEC or anybody else, there aren't any summonses issued. Or anything else here, I understand that you've gotten complaints, that people have made complaints, and everything else. We're left with one alternative, either to move forward together and trying to put together something that works, which they worked very hard to do. I didn't have anything to do with drafting these agreements. They had an attorney who drafted the agreements, my client had another attorney review the whole record and everything else and put this together. So we're in a position now where we either move forward with the community, which is what these residents want to do, and I believe that if you do adhere to these, you will not have the problems that you've had in the past. I believe that this is very detailed, this is not.
Basically, what this says is that they're going to install soundproofing to control the noise, which is something that they've been supposed to be doing anyway. And some of this, I'm just gonna tell you that they should go back and reread this, because the numbers they're referencing on this agreement are wrong. I mean, number 6 says 1, 2, and 3, and it's 2, 3, and 4. I mean, that's just a clerical error, but whatever. I don't, so it says either party can unilaterally deny approval for an event. How does this happen that people in two buildings get to approve or deny an event? How does this, I understand how they get to do that, but they are not the only people that are impacted by this. So what right gives them to, how does that, just explain to me how that works. I'm curious how that.
I'll tell you the best thing that they can do. They reached out to everybody, and the residents from these two buildings, okay, were the ones who came to the table, and these are the ones who they continue to negotiate with, but I'll let Michael.
Can I just say a few things? So regarding that point, then I work backwards. Regarding that point, there was actually 5 different buildings that came together when Jeff organised the meeting. I think it was back in December or January. And I think there's 17, 18 people. So this is not just 2 buildings. And I can clarify exactly who those people are. The people who came up here to speak were not just from 2 buildings. That was probably from 4 or 5 buildings, just to be clear. And as they introduced themselves, that will be on the record if this is being recorded. So it's not just 2 buildings. In terms of that particular point in the stipulation, what they were saying there is the neighbours were basically saying, if one or the other of the buildings did not want to have an event, then they could unilaterally say there's got to be no event, right? So that's basically giving more power to the neighbours. In terms of, I think your overview that everyone is totally fed up. You've had loads of letters, loads of videos, loads of everything else. I think that has been going on, obviously, But I think what is another important point to stress is we have worked incredibly hard, especially over the last 8-9 months, to actually pull this into a better position for both the neighbours and ourselves. And I understand your point about the previously us trying to actually sort the soundproofing out. What I think I explained last time is we had a different consultant who was telling us to do certain things and it just wasn't as effective as we hoped. We have 9 months ago, 8 months ago, got some new people in to really help solve the problem and invested huge amounts of money. So just to be clear, Donna, this is not a wish list of what the neighbours want us to go and do that we are going to ignore. This is actually happened already, including the street guards. And you raise a good point about the traffic situation. We had a consultant in to explain how to actually train those street guards, which are like airport like training. And we brought them in, we trained them, and we have improved massively of that particular issue. And we've done that in collaboration with the neighbours who we've been talking to and getting feedback from. So we have worked incredibly hard on this whole mission to make it better. And it's just so you're clear, this is not a wish list. This is stuff that has actually happened already. And what we're agreeing to is continue with it in order to live in harmony with the neighbours.
So there is a stipulation that what's one of the things about the party buses? Okay, so if you want to hold the special events like immersive theater, sporting viewing parties. I don't even understand this, quite frankly, or other events outside of the hours permitted by the above stipulations that have the hours. Operations will be permitted during any hours allowed by the SLA license. So if you want to have hours past these hours that are listed here, but somehow that would be different than what's on the SLA license?
No, I can explain this quite simply. We basically have agreed to the opening hours set forward in the stipulation, except if we have special events where, i.e., a company wants to come and book our place, then we are able to, with written request, have a special event. So for example, on a Monday night, if Coca-Cola come and go, we want to have a corporate event, a holiday event at your venue, it's going to be 100 people, but we want to go to 2 a.m. on a Monday night or 3 a.m. and we can, to the neighbours who have full control of this, because you can see agreement, if it can break anything, we can get in big trouble and it costs us enormously. So we are allowed to have a special event if the neighbours permit it. So the neighbours are in control, not us.
Well, I guess apparently not the liquor authority either, or your stipulations.
No,
because
no,
if
no,
the
no,
hours
that's-
say 2 o'clock, that's the hours you said on the question we have in front of us. So if Coca-Cola comes on Monday and says they want 3 o'clock, or you mean they won't be able to go past the 2 o'clock that's on?
If you look at the whatever I just put down, yeah.
Okay, so let's just run through this. So your stipulations with the community, which means that's what they agreed to, so would be, and I'm assuming lounge only, what area does that mean?
Lounge only is upstairs or downstairs.
Is upstairs or downstairs?
Yeah. Lounge only is just basically the definition of that is it's not, it basically is DJs, is not DJs, sorry, when it's lounge only. So that is the.
Operating the premises without a DJ, just operating the premises with background music.
Oh, so it doesn't mean, I thought it meant the area marked on the floor plan that says lounge, which is on the first floor.
Well,
It's both areas.
the whole place is really around. That's why it's being changed on the method of operation. Tavern.
Okay, but I'm just since it doesn't define lounge in these stipulations anyplace, the first floor says lounge. And downstairs doesn't say anything, and so since lounge isn't defined, I was confused, so.
Yeah.
What this means then is that Monday, your proposed hours of operation are 5 to 11 p.m. without a DJ, and Tuesday, your proposed hours of operation are 5 to 11 p.m. And Wednesday it's 5 to 4 AM, the DJ will start after 11, same for Thursday, same for Friday. Same for Saturday, and Sunday is just no DJs and open until 11.
Yeah, yeah.
But then what I'm hearing you say is what's in your packet is to close at 2 AM Sunday, Monday, and Tuesday. So that means then you would go to the people who signed this, so one of those two buildings, and ask them on Sunday, Monday, Tuesday, if you could be open till 2 o'clock in the
Sorry,
morning,
it's
because
four.
somebody came for a
Or,
corporate event.
or, no, it is.
No, I understand what you agreed to.
No, but it's, I couldn't even new one, so it's Victoria.
Oh,
No, it actually, it does on which new one?
The one I just handed you in that.
So you changed the hours now on the one you just handed me?
Know which one you have because.
Well, I'm looking at this
Sorry.
one.
So let me just give you the one that was.
I have it.
I just did, there's a thank you.
Okay, so that's different too. So now we're back to, so you're opening at 7 AM.
No, we're not opening at 7
That's what it
a.m.
says on here. It's a 7 AM. I'm sorry, but you now told me to
Okay.
read what's in the packet, so it's in the packet. It says 7 AM to 4 AM, Sunday through Saturday.
So the problem is he's following what was previously there, just recite for Donna what your hours are gonna be each day, how it's going to be.
Okay. Well, what it's gonna be each day or what we have the right to have enough to apply for, so
I
basically.
want to know what hours are going to be on your liquor license. I
Okay.
don't care about your agreement
Okay,
with the
so,
community, I
we
care
were just-
about.
We
your
were
liquor-
just following what our current liquor license is, so that's why I wrote those hours down. So our current liquor license is 7 AM to 4 AM, 7 days a week,
Is that what you're asking for with this change?
yes.
Okay. So then, so my next
But
question.
we're not
is
gonna
gonna be,
operate those hours, obviously.
well, then
We
why
have-
are we
we're
asking
never-
for those hours if those aren't the hours?
Because
Be-
if they're.
He's been here 3 times, we've heard this 3 times already. So what I'm going to say is when you came in 2016, the 7 AM and everything was for the healthy juice bar, all-day cafe, serve it with a full menu of health foods and all these different things that were supposed to be happening on the ground floor for the past 10 years, and I don't know if they ever happened up there, but that's why he had 7 AM. And that, let me just finish what I was gonna say. And to my understanding, I was not on the board in 2016, although I think I was here actually for something and happened to sit in the audience and listen to this, because I do remember it. And I think that the reason that was supposed to sort of appease all the problems that were happening before, to offer something during the daytime. So please explain what he's gonna be doing from 7 AM until 11 o'clock at night.
He's opening at 12 noon.
Now,
12 noon, he's when he's open. He's not opening at 7 AM, it needs 7 AM, 12 noon is when he's open.
Okay, so then what's happening at 12 noon every day? Until, I mean.
So he's
We-
opening for business.
It says,
So sorry, can I just clarify, because this is where I get slightly confused, right? For me, in my mind, there's 2 different things. There's the ability to open if we want, right? And then there's what our normal opening hours are, as in regular hours. So for example, people hire our place to do yoga in an afternoon. We have kids' birthdays at our place. We have Coca-Cola go, they want to do a day party. So for far as we're concerned, on the liquor license, we need the ability not to have to go back to them every 10 minutes because we can. Yeah, so the hours we are operating is midday. Now, in terms of what we're actually opening, you can see on the restrictions I sent that the neighbours have agreed to. It's basically 5 PM to 11 PM, Sunday, Monday, Tuesday, and 5 PM to 4 AM, Wednesday, Thursday, Friday, Saturday. But obviously, because we need to do events, because it's a key part, 20% of our income, we need the breadth on the SLA, so we're not constantly going back to them. But we have to ask permission of the neighbours to do those said events.
So the events that you have between noon and 5 PM, are they not a concern to the neighbors? Is that why it's not reflected in the statement?
And yeah, I don't think I think the concerns have always been later on at night. I don't think the concerns are in the day, but we still will ask permission and that's fine.
So there's permission.
You still have to ask permission of each building for any special event. Any operation between 12 and 5
Anything
is
that's
considered a
outside.
special event.
Anything that's outside the hours, basically.
Exactly.
Okay.
Okay, so. You have any more?
So Terry, you said there'd be no DJs here. I mean, you're very concerned about the hours that were on the license. You said originally that there'd be no DJs here.
In 2016, you're talking about?
Yeah.
No, I didn't say anything. My client said that it would be no DJs, okay?
Good.
Thank you very much.
Okay, he was represented by you. There are a number of,
Right.
and one of the things was that there'd be no DJ upstairs, it'd be background music only. In fact, one of the reasonings for adding the upstairs too was probably has been struggling during the summer months, partially because of the lack of daylight. With the addition of above ground space, we hope to attract daytime business and a more steady flow of income during the summer months. And that went along with a very extensive daytime operation, which we received a significant amount of materials from you guys, but it never materialized. So now the upstairs is causing the street to get shut down at nights, oftentimes because of backup in traffic. There's tremendous noise issues. I mean, I personally witnessed this. Now this street has been narrowed to one lane, so it's even magnified. The applicant is blocking parking spaces in front of their establishment or its legal parking spaces. So all of these issues are actually impacting what the whole premises of the expansion of the license wasn't supposed to be. And I think that that's why there's a lot of frustration. And we get it from a lot of the, neighbors just moving around because it's blocked and traffic is obstructed.
I
So-
understand what you're saying. I understand how things differentiated from what we were first told. I understand that they pivoted in their operations. Right? After COVID, I understand that in the beginning that certain things didn't happen. All I can tell you is I can't change what was. I can only come to you today and tell you this is what's going to be. And then you will have to vote on it. Okay, I don't know what else I can tell you. I can't go back and justify to you why somebody pivoted because of.
So what I've mentioned this several times, I don't know if you went back and watched the meeting. First of all, your client was not familiar with stipulations on the list. So that's a problem, to begin with. And then, I think we gave him a copy of them, or we received a copy of them. And then secondly, all of the things that are being agreed to are the impacts that shouldn't have been there, but now you're saying that they should just be accepted.
No, I'm not saying.
So I
that's not-
don't understand.
Don't change my words. I'm not saying
Okay.
that they should be accepted. I never said they should be accepted. Said once, as things have changed throughout the process. I can't go back and change those things. All I can do is take this client and move forward with the buildings and with the people they've met with who are in agreement with what's written here. That's all I can do.
Right. Well, and they're in
Just-
agreement because the liquor authority failed. and-
No, listen. They're in agreement because this is what they wanted. Okay, this is what they.
That's not what they testified to.
Listen, I don't know who testified.
It was Alexander
There's
Naratov.
somebody here from the.
Alexander Naratov was here. This has been put over so many times. He clearly testified. It's on
The
the
last
record.
time this wasn't put over, and I apologize, the last time I wasn't here is because my brother died. Okay, I couldn't be here. The client wanted to move forward without me because they felt that there were time constraints and the block and the buildings wanted to move forward. If I could have been here, I would have, but I couldn't, okay? So my client being familiar with with the stipulations, again, I can't speak to that because literally I wanted to adjourn it because of what happened, but my client decided to go forward, okay? And a lot of that was because the people wanted to go forward, so we understood that, okay?
I'm just gonna ask one question about that. If the people wanted to go forward so quickly, why did we just get this? Like the last meeting we got here, I'm just gonna ask the question. We just got this yesterday afternoon. So if they wanted to go forward so quickly, why didn't we have something done?
Let me say a few things. Can I just say that I'm feeling like there's a complete misrepresentation of how you guys are viewing the last two times we were here and how I'm viewing them, which I cannot get my head around whatsoever. We did not have people stood up here moaning and complaining and shouting, and this is a problem, this is a problem. We had people stood up here supporting what we are doing. So how you guys are now
Because
thinking.
they think it is the only way that they
No,
can
why?
possibly
No,
get
no,
the
no.
noise to stop, the traffic to stop, and what I don't understand of what they think is that is in their benefit is, to Carter's point, everything that you've been doing, which isn't even to the degree of what's in these stipulations, has been causing problems all over there. I mean, I'm just saying, if you wanna see the traffic that we have gotten the videos of on Lafayette Street, it's kind of crazy, in my opinion. But let me just finish what I was going to say. These stipulations are to have something in here saying party buses in particular should not be allowed to stop anywhere on Lafayette Street south of Drury. Well, where are the party buses going to go? And quite frankly, if it was me writing these stipulations, I would turn around and have written something in the stipulations that says no party buses. I mean, but that's what's in here. That's what, you know, and so I'm just kind of like, shake it, no party buses with music and or lights. That's what's written into this that you've been working on for the past months, right? That's what's written in here. And I'm looking at this thinking, this is what they agreed to. Do they understand that they just are, you know, the way he's been supposed to been operating is with no DJs, background music and everything else. And he's been operating with, let me just finish, because I do get an opportunity to speak. He's been operating with DJs, he's been operating with ticketed events, he's been operating with all of that. Now they have something that he can do all of that. He can have sporting events, he can have immersive theater, he can have party buses. He just has to let them know ahead of time. I mean, I just explain this to me, because I don't understand.
If you give me a second, I'll explain.
I'm done.
First of all, that's what they want. We're not having party buses, okay? They have a fear that there might be a party.
There's a letter in the packet.
It's the letter, is this is. It's been sent to everybody by email. It's in our drive, and it was sent by
While he's
email.
speaking, may I see what you have there? I'll get that.
All right, so let's start with.
There's a drive. But
Well, I just wanna make sure everybody's.
it's right here, Dr. Smith.
Do you have it?
It's in the packet.
So,
It's in the packet.
It isn't in mine either.
all right, so first they did an agreement, a very detailed agreement.
Oh, this is it.
The restrictive covenant of cooperation. So that was drafted by the building's attorneys, okay? This was done by them. They put it together, it was reviewed by another attorney because I was not available for the obvious reasons I stated before, okay?
And
That was actually.
Sorry, I just do want to say, we're very sorry for your
No,
loss. I know it's been a very difficult time, so I do want to say that.
No, I understand. So I was kind of off the board June and July as a result of all that, okay? So this agreement was being done and actually started back in May, okay, just so there's a real history here, okay? And they went through it and they went through it and they had, before the last meeting, at the last stroke before the last meeting, which was another reason, on top of what I told you before, why I thought maybe we should put it off, but it went forward, was that restrictive covenant, okay? That was completed just before that agreement. Then they said, what we should do is a stipulation, okay? And that stipulation is the stipulation that was finished the other day and that we gave to you yesterday, okay? Again, these were not drafted by us. These were drafted block associations, the blocks, the buildings, excuse me, I don't know exactly which, again, I wasn't involved. But they were done with attorneys, there was back and forth. This is what was requested. This was what was agreed to. So in summing this all up, because I don't want you to have to go in a big circle, I don't want to have to go in a big circle, and I surely don't want all these people to sit here and watch us go in a big circle. Okay? What was, can't be changed. What we're here with now is this stipulation, this restrictive covenant agreement, which we negotiated with the residents and ourselves, and with the proposed changes. You will have to decide what you want to do with this moving forward. But my client has spent a great deal of money and worked very hard to make this a better situation there now. The soundproofing has all been done and completed. They've added extra people on the street to help with traffic. So I think if there's anybody here in opposition, I'm more than happy to listen to them because I know what everybody's position is on this committee. I've heard it now. I would suggest we do that, and then if there's anything for us to respond to, we will.
Cause you missed that. Almost all the meaningful violations have been that were put in place, and we've said that this needs to go in front of the liquor authority, particularly with the comments of the neighbors, because it's up to the members of the board to decide if this is okay, of the authority. And the reason is because you have what was a restaurant with a lounge component, which is now a nightclub with all these impacts on the street and everything else. This isn't what's supposed to happen. It's not a little bit of a, yeah, but it's not a little bit of a issue, it's a larger issue. And this just goes back to, there are years of complaints that nothing was done.
Again,
And however it slipped through the cracks, but
I understand.
it's something that leaves us in a terrible position, because basically it means that anybody who opens up and just go do whatever. And you see, we're trying to work more and more with people, but when you come and it's like, you're basically saying, we're not gonna change anything. And we're just gonna take all these things that all these complaints were here in 2016. They're all in my notes. They're all in our resolution. So
asking you to do anything other than. We've gave you our presentation. We've given you the documents. We've given what we've agreed to with the block. I've answered your questions as honestly as I possibly could. Just
let me ask you a
finish. Just let me finish, and then you can ask me whatever you want, okay? We've answered your questions. We've acknowledged there were problems in the past, okay? I can't go back and change what was. I can only go from here forward. If there's somebody who wants to speak for the public, I'll listen to what they have to say so I can respond to you. I know what your comments are, but please, now if you have a question, go ahead.
So do you think it's okay for anybody who's coming from Brooklyn, who gets off the Brooklyn Bridge, drives up Center Street, comes up Lafayette, to suddenly be stopped by private people on the street, not allowed to continue north while somebody loads and unloads in front of a club after 11 PM at night?
Nobody is supposed to stop the car.
That's what happens regularly. That's the norm. And it's the only way to actually control the situation. So what's happening is that the imposition is actually on anybody who's using a major thoroughfare is getting stopped because there's nowhere to pull over. Because it's, especially now, it's one lane, and before they were stopping people in the second lane. It's happened to me personally. And, this is what I hear from everybody around the area. What is that? That's the whole reason that the 500-foot law is there, for the impacts of traffic, parking and all that. Who else rents private billboards that flash signs? And I'm not aware of it. So these are just some of the, traffic is one of the major things.
I understand.
And
Going over this, I get it.
well, I understand, but there is one way, and it's the operation that's causing the problems. It's not, it doesn't seem fixable because it's been so many years. What it is further managing regular people moving by the space because it spills out so much into the main thoroughfare. Now, that's what's happening, and it doesn't, and the city has also decided to further narrow the street, which is even exacerbated it before. But the problem was happening when it was 2 lanes as well. So I don't know what to do, with that respect, because that's just what happens.
Now,
And
all we can do is we control the crowd in front as best we can, like we said we were going to, which this document.
but it
Just
wasn't
let me
supposed to
finish.
be there.
Let me finish. No, you're asking me, in one breath, you're asking me, what can I do to change it? And in the next breath, you're saying, well, it's been there, so nothing can be done about
Well,
it. Just please let me finish, okay? Because I don't want to belabor this
No.
point, and we keep going around in the hamster wheel here, and I think it's counterproductive. Okay, I understand what your position is towards the past. I think you understand what my position is towards the future. either you'll accept that or you won't, but my client just wants to answer the one question you raised right there with regard to that issue.
Traffic, no.
And I'm just gonna say one other thing, Terry, that if this.
Can I just
if this-
answer about the
oh, go
traffic?
ahead.
No, otherwise, because I'm losing my thread of thought, because there's so many things and I feel like I'm sitting here quietly and actually haven't had a word in for 10 minutes, right? So in terms of the traffic, I get the frustration, but I think we're losing thread of a point here that we have invested in people, methods, different ways of operation to try and improve the traffic. So when we had these consultants in, they suggested maybe you put one of these signs up that says do not honk. And I know somehow that's offended you, Carter. I don't know why. That was suggested to us. It's not us trying to take over the neighbourhood. It's not us thinking we're too big for our boots or anything like that. That was suggested to us as a way to stop people honking, which was done because of neighbour complaints about a lot of honking going on. So we're not just trying to take over the neighbourhood. What we're trying to do is help traffic flow at certain pinch points. This is not all night. This is not going on all day or night. There's certain pinch points that is a problem. And we have identified those and we hire now a whole traffic team who are helping the flow. I'm sorry if they tried to stop cars. I wasn't aware of that. I'm actually out there very frequently till 5 o'clock in the morning working with these guys. I was there in January in the snow. I'm still there now. So I am genuinely can say from personal experience, and Alex can attest to this, I am trying to keep the traffic going and I'm not trying to cause problems for the neighbour. So that's just the point I want to get across. What was your other point, Ken?
You know, my point is that we have plenty of businesses, they don't impact the neighbors. They keep what they do inside, do whatever. We rarely, I think the attorneys who are here, they're not gonna hear, but you know, we don't, there's not a problem. People aren't making complaints. And what here is that this is all has spilled over and a lot of this is just mitigating it, but it's still there. And I think that given the density and the saturation of licenses in our whole area, when we have something that creates this big of an impact, it actually creates a situation where we can't do anything else. So there is no more room and we can't have these kinds of traffic impacts just expanding. So you guys just went ahead and did this operation and changed it without any permissions, in violation of all the stipulations, without a focus on the daytime operations. You took a long-term business that was well regarded and didn't have issues in the past and expanded it into something that has all sharp elbows everywhere. And now these mitigations are just saying, well, we have the sharp elbows, so we're just gonna be here. I just don't.
Well, apart from it couldn't make money. That was the one problem it did have as a business. It was sliding and was nearly bankrupt when we took over it. So just so we know the commerciality of that business.
Well, but you signed an extensive agreement to purchase it. I mean, that was what it was at the time.
Again, we're going back.
No, we're not, actually, we're talking about how we got here, right? And a part of that was an expansion from a basement place with a side entrance. One of the things is when the expansion went up into the upstairs, one of the agreements is that you wouldn't use both entrances in the evenings, it would just be primarily on the first floor of that entrance. And this was all to kind of try to move this around to mitigate some of the issues. And the issues started right around then. And that's where all the things started coming in. That's why the last time we were here, had those agreements in place and then it wasn't done, but the situations expanded. So I don't know, you know, where that leaves us. I understand that's business, but you know, we didn't make that choice. You did do an extensive agreement with the previous operator. It wasn't, you know, it was purchased and, you know, there was a whole, and then it was expanded upon. So, I mean, so we're left with this situation. But when you go by the place, you see all the impacts, and that is not what we see at other places. So.
Your point is, no.
I just wanted, so just in this other part of the agreement, did Ambleside reimburse the condo associations for their lawyers' fee to draw up all of this? Is that
Yes.
Ambleside? Okay.
Donna, can I just raise, I forgot one of the points that's really important. So the point you made about the party bus, just to be clear, because I think maybe that's a little bit, there's not the clarity. They are not our party buses. What you have is, and I think what the neighbours were referring to, you get this almost like mini buses which fit like 15 people, and they drive around the different area downtown and nightclub with flashing lights on and music. We don't let them stop outside ours, we don't let any of our guests in, but I think they just wanted it in the agreement that they do not want them outside on Lafayette Street, which we don't anyway, so they have nothing
But
to
the
do with us.
event, I mean, part of the thing is, you have the space that's your space, and the sidewalk right in front of it. In theory, you don't control the rest of the block.
No,
You don't, I mean,
I understand.
and this is, you know,
But this-
all of this with the cars coming. I'm just saying that might be what these two buildings wanted, but if I have two, I'm sorry, but 5 buildings may have been here, but 2 buildings are on this. 5 buildings are not on this, 2 buildings are on this. And, you know, if every operation that we have in this overly saturated community board with, you know, high-end places all over the place, wanted to put signs outside and just take over the sidewalk and have, you know, traffic people doing this, and we're allowed to behave in this way, there would be no place for regular people to do anything.
Can I just give you feedback on that? I'm feeling like I don't think I'm not sure about the challenge. It's like we're damned if we do and we're damned if we don't. We are doing this, Donna, to help the community. So now you're saying, well, don't try and control the party bus because it's a private party bus and they should be able to park where they want.
I'm
It's like,
saying the street is not your street.
Yeah.
I said this last
So we-
month, the
trying to
street
help,
is
yeah.
not just your street, and everybody's impacted by what goes on the street. And if another business opens up across the street from you, they're going to be impacted by all of this as
Okay.
well.
But we're trying to help.
And then what I said last month was one of the things that would alleviate some of this would be not expanding the DJs to both floors, not having sporting events or immersive theater, not having so many ticketed events, closing earlier so that at least when the people left, the noise would stop between 2 and 3 instead of between 3 and 5. All those things, or just showing for you know, a little bit of time that you could operate in I mean, a high-end cocktail lounge downstairs with things, so that there would be some faith of some ability to understand stipulations and adhere to them. And I think part of what Carter was saying, this just amplifies those impacts, and what's been shown by this is that it's been pretty detrimental to everybody. That's.
Okay. So just so you know, stuff like the immersive theatre and a lot of that stuff, that's more of a daytime. And that's been going on earlier on than it, so I get what you mean, but it's.
That'll be 100
limited.
people then taking up the sidewalk waiting to get, the Museum of Ice Cream has, I mean, it's the same, if that's what you're talking about, now we can have a conversation about the 100 people with tickets waiting to get online on the sidewalk, which isn't written out here, but if that's what you're saying is what you want to do during the daytime, that's a whole other conversation of impacts to the community of that sidewalk. And I've gone by and seen the lines waiting to get in. At actually one time it was 9 o'clock at night when I walked by, so it wasn't even that late. But if you're planning to do that at noon on Saturday, that line will just do that, and then it will.
That
Or
would,
to the next thing.
that would happen only under this agreement if the.
But this agreement is not even, I'm just gonna say, none of that is represented in our packet. None of that is represented in our packet. In fact, I mean,
That's
so this is like, you know, what was.
The packet doesn't have a space for where you have a stipulation or an agreement. with-
Well, but the packet starts at 5 o'clock at night.
I understand that.
So, I mean, I don't know how he's having an immersive theater at noon when what's before us, the application that was before us was 5 to 2 and 5 to 4.
Evening, sorry, it's evening. Anyway.
That's not.
I think
Yeah.
in short, the agreement with the neighboring buildings are fairly useless to the community board.
I understand what Donna's saying.
So,
No, what Donna's saying is what they're doing is, and I understand what you're saying, okay? They don't address the concerns that you have raised before and now as thoroughly as they're, and you don't think that they're gonna help with the conditions that you're seeing right now. That's the position you've made, sweetheart. I understand what you're saying.
Okay.
yeah, I mean, for example, number 19 is about widening the sidewalk. I mean, that's not the purview of the business or the neighbors. I mean, that's, or CB2. So that's,
Well, at least not this committee.
Not this-
that's fair, that's fair.
I just, there's somebody here from the public.
No, is there anybody here from the public who wants to speak on this? Come on up.
Yes, I'll take it. Thank you.
So Alice, I'm the narrator of 57 Prince Street. A resident in one of the two buildings that were part of this agreement was made with gospel. Please understand that both these buildings are in response mode. We're not advocating for the club. We're trying to find a practical way for us to be able to live with it. Because it is, club is there and it didn't close, it's operating. So we try to negotiate with them an agreement that makes it possible for us to cohabit our space. I'm not a signatory to an agreement, I'm a tenant in the building, but I was involved very thoroughly with the negotiation of agreements. Yes, we understand that this is a private agreement, not one that's, we didn't need us on behalf of the community more, but I think we took account as much as we could, all the neighbors. You know, the two buildings that were primarily affected directly initially were the two buildings adjoining the club. A lot of what is in the stipulations that we proposed and that we're hoping that maybe the community board will adopt because was already negotiated. A lot of this had actually happened already. Soundproofing has happened and has been successful beyond what I actually initially thought. So congratulations to gospel. They actually did make what amounts to a recording studio level sound isolation. The traffic before Lafayette Street was narrowed, the traffic was working. The two moving lanes and the parking lane was absorbing enough of the cars loading, unloading, so that, you know, the traffic agents, in fact, they started off amateurish, they weren't working at all. I think you were getting testimony from last winter and spring. All of that has actually been improved. They actually did manage to control traffic to the point where even the narrowing down to one lane has not been a disaster. Since I'm not south of Prince Street, I think somebody, you know, would have to testify to what is happening after the narrowing south of Prince Street. But you know, it is a fairly competent crew, and I think they have advanced the traffic problem substantially. Street noise from the people waiting, not so much. I think that's a problem. I haven't personally, or no one hasn't, you know, come up with a theory. How do you do that? They tried to stagger hours for events, so I think, you know, maybe it's not as bad as it was, but I think that's the lesser of the problem. Direct noise, traffic, and honking was the bigger problem. So, and let me address the agreement that we made. There's some confusion here, but we try to establish. So we're trying to classify the uses within this operation. One is what we call a lounge use, which is the bar and the non-nightclub type uses. And those uses for us are much less of a problem. They don't cause as much noise. They're not as popular. So the traffic problem is just inherently not as much of an issue. So we have much less concern with it. So we were focused on the nightclub use with DJs and so on. And in the agreement, what we have accepted is Wednesday, Thursday, Friday, and Saturday, 4 nights, 11 o'clock at night till 4 in the morning. For those 4 nights a week, plus a number of holidays, or particularly the nights before the holidays, and you define the number of acceptable days, because obviously calendar days don't match holidays. So that we've accepted as hours that we'll live with. We also try to negotiate a situation where the club would take for gospel will operate during the lounge hours by permission and would convert to a club operation in those hours from, I think, Saturday to Sunday at noon, or regular days, 5 o'clock up to 11 o'clock. So by permission, they'll be able to have a special event with DJ in that time frame. The one issue that, you know, where we did not know how to even express it, we're as 2 buildings next to the club, we're okay with them and to ask us for an event that would go beyond those hours on Sunday, Monday, and Tuesday. But up to whatever hour they ask us for, 2 in the morning or 4 in the morning. And with the understanding that the 2 buildings can privately say, no, we don't want this event because of special events cause problems that are worse than the hour you accept. Never give permission to them. How that might be expressed in the license, I don't know. Because these are supposed to be limited to, like, I think it was said, the maximum for a Sunday would be every other Sunday. That's in the agreement, so I'm not sure how that becomes a legal matter or not, our problem. You know, we accept some special events, but not on a regular basis. So that's the question about what a lounge is. The lounge is that we call it the lounge use, which, you know, includes, you know, any daytime use. Frankly, there hasn't really been very much of it. They occasionally have events, but really the operation runs noticeably to us from 11 to 4 in the morning with 4 nights. And, you know, I'll say that they have made very serious improvements, and whatever complaints were issued, but really possible traffic situation before, and completely unacceptable levels of noise, that has been resolved. Give you credit. But this is all, we're responsible. That was our way to respond to the situation.
Got it. And so I just want to say that lounge situation was what they were supposed to be doing since I mean, it was supposed to be a lounge downstairs, it was a cocktail lounge. It wasn't a full service sit down, white tablecloth restaurant. It said everywhere it was a lounge. Just with the no DJ, well, exactly what you're describing as a lounge is what it was supposed to be.
What it was
So,
supposed
so
to
which,
be.
as you just characterized it, is not that problematic.
Well, that would not have been problematic, but
Right.
obviously they.
That wasn't what they did. Right, okay. Got it. Thank you. Is there anybody else?
Hi, I'm Heather Pucci. I'm at 101 Crosby Street. I'm not part of the agreement. Technically, I'm a free agent. So, I'm just, here to say that, I've said it before, they have made great improvements to echo what Alex has said to the traffic, the control of the traffic and the people outside. They were making better improvements until the DOT reduced us to 1 lane. So now it's sort of undid a lot of it, but it's not their fault. So we do see the efforts. They've worked with us on the agreement, even though I'm not part of the agreement, but have worked with the community. I just want to, the community shares the concern that, Alex briefly touched on about the special events on like Sunday, Monday, Tuesday. you know, how many of them, that kind of thing, because I don't think anyone wants to have a nightclub 7 days a week till 4 a.m. So that is, you know, it's difficult, I think, because I understand how liquor license works, and I don't think really fans gonna want us to be like, oh, on every third Sunday, we're gonna do this and this, and we're gonna have to get permission, so it's gonna be a little difficult to try to articulate that in the license and stipulations. So that was our concern. And then I just want to say, Carter had mentioned it before, why the agreement was written. And the agreement was written because the state liquor authority did not respond to us and did nothing. So we reached out to them multiple times, via email, phone calls, consistently for over a year. No one did anything, and we were forced to have to spend, I can't even tell you countless hours to try to make an agreement, because we had no other recourse, so. Thank you.
Thank you. Is there anybody else here on this? Okay. Terry, I don't want to rehash anything. I just want to ask one, what I think, hoping is a simple question. What are the actual hours, not in the agreement, that is in our questionnaire, that we are supposed to be? Just, what are they? Because is it the 7 to 4? Is it the 11 to whatever?
I think it's on that new pack that I gave you, Donna. It's,
So that was 7 to 4. That's why I'm
if
asking
we
this
think we
question.
put okay, so I'll change it to 12 midday. I was just keeping it the same because I thought that was easier, but if it's 12 midday till 4 a.m, okay,
Okay, so 12 p.m.
12 noon to 4 a.m.
12 noon to 4 a.m., 7 days a week.
Correct, yeah.
Thank you. Okay. Does anybody else have anything? I think that we can conclude this. Thank you.
Yeah, thank you.
Well, the rest of you some.
Yeah, you too, Darren. Okay. Next up, Center for Emerging Culture. Okay, let me just explain. Max will explain really, but I'll just give the prelude to this, which is the only reason that the OP is on here is because Max sent a re-notification, Mr. Bookman sent a re-notification for the on-premise members club, which we've already heard, which was for the 4th floor, the 5th floor, and the rooftop. They have removed the rooftop. I have one simple question about that for them. That's it. So since they were coming here to get the Tavern wine for the members club, I just left it on there so that I could say what I just said.
Thank
And should I just ask you my one question on that one? Does that remove, just give me one second, Max. All I want to know is how many seats we're left with. I think it removes something like 26. Like, in other words, does the count go down to what the rider is for the Tavern wine?
Count goes down to what the rider is for the
Thank
Tavern wine, although it's actually called club wine.
Right.
But- So just to put my name on the record, Max Bookman, Pozeski and Bookman DC, counsel for the applicant. We're not looking to rehash everything tonight. No, I'm sorry, Tim Phillips, my client, applicant principal to the right. So, as this board well knows, a few months ago, we were in front of you for 2 applications for this building. One was downstairs for a beer and wine license for a catering facility, and one was upstairs for a full liquor license application for a private members club. We endeavored greatly and dearly to reach an agreement with you, and we were so close. We were on the cusp of an agreement. We were extremely disappointed that we couldn't get there. And these things have consequences. So one consequence of our lack of agreement is that, based on the way the law is written, the upstairs application for full liquor is not eligible for a temporary liquor license. Another consequence is that application will be going to the SLA full board. Those 2 things together create a long period of time where my client is not able, would be otherwise unable to have.
I heard today that they're caught up and that it's quickening.
That's not actually what happened today. They said they were caught up on their disapproval letters.
Oh.
It was taking 18 months to issue a disapproval letter. Now they say less, but we'll take everything with a grain of salt. Point being, I don't know when the SLA full board is going to call this application for the for either the downstairs beer and wine or the upstairs full liquor. And creative as we are, we have noted that the beer and wine license application category does not have the same rules concerning the eligibility for a temporary license. So what we have done, this is simply a application mechanic, is we have submitted contemporaneously, side by side, a club wine, a beer and wine license application for the upstairs club, just so that we can be eligible for a temporary beer and wine license for the upstairs club. When I was on the way out the door that night, I told you I was gonna do this, and I've done it. And so that's all this is. This is not an effort to try to persuade you to vote for us, in favor of this application. We certainly would welcome your support, but that's not what tonight is about. I don't, just in all honesty, I don't expect this to be something that's going to make you suddenly support this application or make any of the neighbors support it. This is simply to create eligibility for the beer and wine license. The way this works in the end game is if we are approved by the SLA for full liquor upstairs, which I sure hope we will be, then this beer and wine application would be withdrawn at that time. So that's what's going on.
And just for clarity of anybody who's here, what are you permitted to do with the temp license? My understanding, there's no restrictions on this temporary license.
That's correct. There are no restrictions on a beer and wine temporary license.
Okay. I have a couple questions. So I have a bunch of papers on this, so just let me stop it. Right, first one was, I'm just looking for. Okay, so. The rider now has, it has 200. 200. For the fourth and fifth floor. And so before it had 226. So I'm assuming the 26 is what was on the roof.
Yeah.
And so that's why that changed. Why did the special events had before 464 and now it's 249? So I'm not complaining, I'm just asking why that changed.
We've had some ongoing and continuing discussions with our other professionals who are involved here, dealing with other agencies, and we feel that that new number is what's appropriate.
Okay. Okay, so that solves my first question. The second question, I just want to run through. I know we had a big back and forth with this before, but I'd just like to do this one more time. How people get up to the fourth floor.
The same way, that hasn't changed. From
Okay, so
what's
this,
on the record.
so the stair, so there's the elevator that holds about 8 people. There's the 328 square foot lobby that people walk up the steps to come into. And then there's this stairway on the southwest corner.
So Donna, I'm not looking to be obstinate or uncooperative.
Right.
This was this was discussed in detail. This is all recorded.
Right.
Anyone who's interested can watch the recording.
Okay, well, let me just ask one other question then, because things,
I just don't want to be, I don't want to accidentally say something that can be perceived as inconsistent and be told that we're saying different things. What I can tell you here is the means of access that we described in detail at the last meeting has not changed.
So the southwest stairway that is supposed to be a means of access, when this applicant came before our landmarks committee, that stairway is not built. They came to landmarks for that stairway. It's an exterior stairway according to what was presented to landmarks. That's going to have some kind of wall around it, but it's exterior. It's not there, so it's non-existent. It's your second means of egress. It's non-existent. And they said it's for egress only. It's not to access, it's not to get in, it's only for exiting. It would be pushed forward with exit signs. So the reason I'm asking is because when we went through this before, that was how people were getting up to the fourth floor and the fifth floor. That was one of the means of, building stairs up to the third floor, and then it says building stair entrance to fourth floor from the lobby is through that stairway. And then it says entrance to fifth floor from Howard Street. And so in light of what was said at that meeting, I am asking that question because it appeared at that meeting that this is only an emergency egress and not a way for people to enter. And the applicant additionally has plans on their website or that they, for events, that clearly mark that stairway as an egress stair, not the other stairs, entry vegetables and everything else, but this stairway is marked on every single floor plan as egress. So I'm asking that because right now the certificate of occupancy, which is one of the things we raised with the temp license for the catering establishment, that certificate of occupancy is for 47 persons per floor. And what is on his application, presumably what was sent to us for the second and third floor, we're not discussing the second, third floor, so we'll just discuss the fourth and fifth floor, is 200 people combined. And without having a second means of egress, this is a real safety concern for us with 200 people for someplace that has a capacity of 47 per floor with no second egress. And I mean, it's a real concern. So that's why I'm asking, you may not know the answers to this, but that's why I'm raising this issue, because he's operating, he's renting the space, he's holding events, presumably, well, that's my other question. So I'll just go to my other question, that you can answer them all. Has he been holding events on the fourth and fifth floor, and has there been, getting one-day permits for that with alcohol, or has there been no alcohol, and what capacity has been operating under, if he has been operating?
They've been having small, let me take them backwards. They've been having small events, on fifth floor, not the fourth floor, under 40 people, no alcohol. To address your initial point, thank you, Donna, for raising that point. I appreciate that information. Yes, I am aware that there's been landmarks committee hearing, or landmarks LPC hearing. This questionnaire and package is not was not changed to be in harmony with that. I will take everything you said under advisement, and we will consider it and make sure that we are ready to address it when you and I meet at the full board on this.
And my other concern, which I guess is gonna go to the liquor authority, but when they're just doing these temp licenses based on the materials in front of them, since the materials in front of them say, it just says building stairs up to the third floor and down to the ground floor. There's nothing on these plans that were submitted to us and presumably to the liquor authority that say that these stairs don't exist. It implies that they are there. So I don't know that anybody at the liquor authority would really be looking, but if they're looking, it looks like there's proper egress here. And there's not. So that's the other concern that I have, is that they're just issuing a temp for 200 people, and they issued the temp for the 200 people on the second and third floor. I'm raising both of them because it is the same applicant. That's 400 people potentially, not saying it happens, but 400 people potentially in this building, where currently right now it's 47 people per floor with no second egress and an elevator that holds 8 people. Not that that's proper egress either, but and I know I've been in the building, so I know the stairway from Broadway, it's not that big. So it's something that I hope you seriously consider, because this is a serious life safety concern in that building.
And I want to assure you, Donna, my client has engaged a number of department buildings, professionals and architects. I've been on many calls with many of them. They are taking this issue seriously. I want you to hear that from me. I'm not in a position today at this meeting to give you any new information concerning that, but I understand.
Yeah,
concerned to
I
ask
mean,
about.
it's just, because the work, I mean, whatever they're trying to do to get it done, doesn't mean it can't be done, and doesn't mean that at the end of the day, that occupancy will be able to be met, but currently it's not. And with the temp license, that's the concern, not that he's not trying to do it and not that he won't accomplish it, it's just, right now, it hasn't been accomplished.
I understand your point.
Okay, does anybody, I don't have any, those were my questions. Does anybody on the committee have anything? Carter?
So there, a number of violations were issued and there's still a full stop work order on the building. And it looks like a number of the complaints are still open. Why were those issued? What's the plan to resolve them?
I'm not gonna be addressing DOB violations at this time. They are, we are aware of what you've just stated, and they've engaged professionals to address those concerns.
But I mean, some of these seem to be tied in to the plans to change the building. And there are already events being held there. I mean, that's a big concern if the DOB is issuing stop work orders, including building a bar on the third floor. And they're not accepting, it looks like the certificates of correction for those. And those are the spaces that you guys are operating in. With the temporary, I mean, that's a big concern to us because this is supposed to be an office. In the office, that's the allowed occupancy now. An office space is not an assembly. Even though the number is not higher, so it's a very different type of use in the building. And so when you have groups in for events and et cetera, that's the concern, is that it's just not safe. So I mean, if you guys aren't commenting on that, I'm not sure what you leave us with. And you know that I testified before the liquor authority when they waived this, and this is also Commissioner De Leon's issue, with respect to these things. And so there's an active violation without any comment on it with respect to that. It's just very concerning
I hear you.
to us, and it just seems to be a workaround to get one license issued that's going against another agency and then saying, oh, these are two different agencies, when there should be everybody working together to have a safe environment on this. And this just is a concern given how big the space is, right? And if it's jammed up through time and getting things approved and it starts costing significantly more money and you're not able to use the space, that's starts to put a lot of pressures on things in a big space. And that's where the concern comes from, because there should be absolute clarity on what's happening. And that's, however that's agreed upon, just absolute clarity on what can and can't happen for everybody involved. So
I appreciate everything you're saying, and I want to reiterate again that I could personally testify from my own experiences with my client and the professionals they've engaged on, that there are a lot of minds that are experienced in this area dealing with the DOB issues. My point in not commenting on that tonight is only that my view of this appearance tonight is our opportunity to persuade you to support this application is over now. And that ship has left the dock, and I'm happy to be here tonight because you invited me, but we know, I know where you stand on this application, and, we'll hash this out at the full board, unfortunately.
Okay, I do have members of the public here, so members of the public, I have Michael Kirk and Pete Davies. I'm just gonna ask you, since we've already heard this application so many times, I don't need new information. I mean, I need new information, I don't need to rehear any old information. Come up and put your name on the record and just make a brief statement or a new statement. Come on up, put your name on the record and say briefly what you'd like to say. I'm not trying to shut you down, Pete. I just don't want to rehear it again for 20 minutes.
I'd rather be upstate than be here.
I understand.
My name is Michael Kirk. I lived at 53 Howard Street, for the record. I appreciate all the questions you both asked. They're pretty much echoing what I said in my letter we sent. And, you know, I don't disagree with you. There is no second means of egress presently. I did a little digging and again, it parallels everything you said. With a temporary license, my understanding is, you can't extend your hours beyond 12 o'clock.
No, so just, that's why I asked, Matt, I just want to clarify that. It's a temporary license for wine and beer has no restrictions on it, and that's what this temporary license is for. If this was a temporary for an on full liquor license, that has the restrictions on it, but wine and beer does not have any restrictions on it. No time restrictions, no music restrictions,
Okay.
no anything. It's up to you to see
Now,
how the operator operates with no restrictions.
one last thing, just this point of their, stop work order, which is posted. But I've noticed of late, they have a placard which conveniently hides that record from the public. I've photographed it and I'm amazed that it's strategically placed. So as you pass the building, there's no evidence that that's there. And it was there. And I've also noticed when it's up, it's chained. So there's a purpose to it. I just want to point that out. And that just echoes back to our mistrust of what's being presented or how it's being presented or how they're pursued. Thank you very much.
Thank you. Now you can go back upstate.
My name is Pete Davies, speaking for myself. So we've been doing this a long time. And previously, the representative for the applicant, when asked about occupancy, said we will do whatever DOB lays out, which seemed to indicate they would abide by the certificate of occupancy, although they've never said that. So we're hearing tonight that there are no restrictions, that this applicant can do whatever they want under the beer and wine for the private club. With, I don't even know now if that's based on paperwork. Does their own paperwork limit them in any way? So they could go 24 hours a day with 1,000 people in the building if they want. Maybe that will get answered later. What we know is that the legal limitation for the occupancy of the building is 47 people per floor. Now, I cannot imagine that the SLA would say, oh, no, there's no restrictions. They can do whatever they want. And if they will not say, no, we will limit to 47 people per floor, then we're in a world of hell right now. Because that means they are willing to risk not only the patrons, they are willing to risk neighbors, they are willing to risk quite a bit just because they figured out a maneuver to get a temporary license, which gives them the allowance to operate as they wish. So I just don't see, I mean, anything that y'all can do to get the SLA to understand that what is being presented to them in the paperwork that they have submitted is not the reality of the building as it now exists and as it is being operated and is being marketed for 100 people per floor, actively marketed 100 people per floor, which is beyond the legal limit. So this idea that, no, they can act with no restrictions. I think everybody needs to take that with a grain of salt. If there are no restrictions, then hey, why are we even here? Thank you.
Thank you. Anybody else?
I was just gonna say, there is a recent precedent where a private members club was called before the members of the authority to discuss the issuance of a temporary license. And that was what, 609 Fidel, Paddle, whatever it is. Fidel. So there is a precedent that the liquor authority did in fact call before the full board there for a decision on a temporary license. I don't recall why that was the case, but it was done. And that may be something that the community might want to request.
How do we do that?
I assume it'd be through a letter to
Licensing.
the Commissioner of Licensing, mooring crews. To plead the case, given the circumstances here.
Max?
Just to clear something up for the record, so when we say no restrictions on a temp, what we mean by that is no restrictions on the method of operation, so things like hours of operation, live music, what have you. We are always limited by local building code and what the local Department of Buildings requires. You know, on the DOB issue, the only thing I'll just add is, you know, when the SLA issued that advisory, their point was that they're a statewide agency. There are many, many municipalities in the state of New York. All of them have their own building codes, departments of buildings, rules, etc. The Liquor Authority was notoriously bad at understanding Department of Buildings rules and requirements. Been around long enough that I was plenty familiar with that. Applicants were good applicants were stymied sometimes for months because the Liquor Authority pretended to be the Department of Buildings and would refuse to issue licenses based on their reading of a certificate of occupancy that didn't actually comport with what the Buildings Department itself was requiring. So the Liquor Authority got out of that business. In New York City, practice before the Department of Buildings is complex. It's nuanced. It's rarely as black and white as sometimes it is presented at these meetings. We have smart people working for us who are operating in good faith, who are professionals dealing with the Department of Buildings, who are advising my clients following their professional advice on what they're being told is permissible to do under Department of Buildings rules. And they will never hold an event or have any type of occupancy that is contrary to the advice that they're given as to what's permissible. Now that someone may be able to pull out a C of O and say, well, this says office and this doesn't look like an office. It's more complicated than that. And I just want to assure you that my client does not have a flip attitude about this. They're taking it extremely seriously. It occupies a significant amount of their time getting this right. And they're going to continue to do so, and we'll make sure the State Liquor Authority knows that as well.
Just a quick question, then why are there stop orders on this and certificates of correction that haven't been accepted? You said
Well,
a
I'm not a DOP
violation.
professional, Carter.
No, but I
can't tell you why.
No, but
They're working.
you said they were working under the guidance of
Yeah.
some higher level, then why are there all these violations?
I can't speak to that. You know, violations happen and then they get corrected and it's a complicated administrative process. And they're working on it with their professionals.
Dr. Smith?
I don't want to use that one, thank you. That one doesn't work. So thank you very much for your statement, but you might not have an answer, but I'm extremely concerned about the lack of the safety with the lack of egress, the egress, just to let you know. Thank you.
Thank you. And I understand, I'm hearing the safety concerns. There is appropriate egress in this building for the occupancy that they have when they have it. In other words, this building has not been filled to the numbers that we've been talking about at our last meeting yet. It has been much, much smaller than that. And it's been significant. Most of the things they're doing are like 40 people. So I am confident that what they have done is safe. Obviously, as you've been hearing Carter point to, there's work to be done with DOB. When those things are accomplished, that will unlock the ability to occupy the building even more. With even more people, all of which would be subject to whatever we agree to with the liquor authority. We had proposed limitations to you.
Thank you,
That's not on the table anymore, so
Which one's proposed to the liquor authority?
we'll see.
thank you.
We got some time to think.
Okay,
Thank you.
yeah, we're good, thanks,
Thank you, everyone.
thank you.
Thank you. Have a good evening.
Okay, so I went through the ones that we waived. So we're done. Is there any new business?
No.
So no, so we're ready to go into business session. Does anybody need to take a break or can we just go? We can just-
Good night, everyone.
Good night. Okay. All right, so let's just go through in order. Because the first. Okay. Okay, so the first one is blank form. Tavern one, previously unlicensed, Lafayette Street, 5 to 12, it's upstairs. Broadway Residents Coalition did not have, I reached out to Pete, they did not have any issue with it. And they have a place in Brooklyn, I looked at the Brooklyn side, it looked like fun. I mean, they like music things, they're all selling out, so this is just really to support beer and wine for that space.
So I didn't ask the question, I was just thinking about it now. What type of music do they?
It seemed eclectic, a little cello, but modern, possible, I'll send you the link to their website if you wanted it. Different singing, different stuff, and book readings, I think, and
Yeah.
stuff like that, so. Are we denying less on that?
Yes, yes.
Okay.
On the drive. So maybe just 251.
In the drive, it's noted, I have to change the address, and that's
That's a different address.
it's because when they sent in the first 30-day notice, they had the wrong address.
Are we talking about blank one?
Yes, in the drop, yeah. Okay, the next one is Nico Grand. That's the double floor sushi hibachi restaurant. 11 to 12, the TVs, it's 2 TVs, sound off. And it's his first restaurant, but he's been managing for how many years? 15 years. And, you know, previously it operated pretty much the same way. Outside, so is this a deny and less?
Yes.
Yes.
Okay. The next one was La Vita. It's a change to an OP, they've been operating since 2012. So the only issue back in 2012, when I found that, was the comments, and it's in the drive, were the comments about the enclosed sidewalk cafe. We said he'll get rid of that.
Okay.
Is that good enough, or should I say that that area is not part of the licensed premises, because it shouldn't be?
Yeah, I think we should say that.
They said they would, right?
They said they get rid of it, but even if they don't get rid of, you know, it's got a concrete, he may not get rid of it, but I mean, he said he would, but it's, I don't know that, it's not, it's been there since before 2012, it's not one of these.
Just remove it from the bag.
Yeah, okay. Yeah, that's it.
You can return when it was there.
Sidewalk or something. Okay, so we deny less? Number 4 was 357 West Broadway, and they are returning. Did try to not have them. I just want to get that one cleaned up, I don't think that. Okay. So now we're on Ambleside, we sent a resolution in last month denying it, because they did not.
Yeah.
Even though he said he was laying over, I received an email, I don't know if that's in the drive, but I'll make sure it is, that said that they were not laying over. Because they've waited long enough. And that was the day before full board, and Terry but he wanted to come back and said he would check with his client, get back to me the day of full board, and I heard nothing. So we have a deny resolution that we have passed. That is our position.
Is there anything that needs to be changed?
So I'm just trying to pull that out just to see if there's anything. We basically, it outlined the traffic, outlined the 311 complaints, outlined 2016, there's a lot in there, and it just, I'll just read the last whereas, because the applicant has a long and extensive history of violating state relations agreed to with CB2 Manhattan, which were made a part of their liquor license going back to the inception of their license, having no regard for the approved method of operation. CB2 Manhattan believes this application should go before the members of the authority for an evaluation and complete review and final determination, especially given the extreme negative impacts the operation has had on this community for years and lack of regard for the rules, and therefore be it resolved that Community Board 2 denies the application. And that CB2 requests that these applications, because it's the two of them, are considered by the New York State Liquor Authority. Respectfully request this item be counted or placed before the members of the authority. So I don't. Does anybody think we need to do something further?
No.
Nope. Is there anything I need to do? Do I need to?
We spent a lot of time on it.
Yeah.
Anybody have any other thoughts that need to be, it's the same?
Yeah. Do I just need to say that they came and?
Yeah. I said that the position hasn't changed.
And that their hours now are noon?
I don't think
I don't even think it's irrelevant. Yeah,
But I think what you read is.
okay, so just they returned in the position unchanged.
Right.
Okay, so that's deny unless, and there's 5 of us here. Okay, and then the last one is
Center for Emerging.
Center for Emerging Culture. We denied the OP. They're just going for their temp side. Is there anything here?
How does that work? In
This
terms of our,
is the same, it's a separate application, so I have to basically. It's all the same reasons that were laid out in the other one. I think the one thing I would do is put in the closing thing where there will be a resolved, would say that we ask that any temporary license somehow be limited to the certificate of occupancy, the current certificate of occupancy, and I'll point out that the stairway is not built, which I believe I did in the first one, but it's clearly, this document came from, this one, member of the public linked, had someone, had happened to coincidentally apply for an event there. Anyway, in the, let me just check and see where I put it. Background, there is a folder that says info from Ruba. And it has some, they were inquiring about course 2 and 3, but within that, there is somewhere that says full building plans. And the full building plans very very clearly show that that doorway, unbuilt doorway, it as egress. And,
Is it just a function of that they haven't changed any of the paperwork forever?
well, no, this stairway they put on, this stairway is non-existent. so
No,
they-
I know that, I know that.
Well, but I don't know, I mean, when they went to our landmarks committee this month,
Or they were this month.
and I can put I pulled out a little snippet of the transcript, but I can put that as. In fact, I can just read, it was specifically asked. What? One of the community board members specifically asked, is the intention of the stairwell purely for emergency purposes, or is it also to be used as regular means of egress? For example, will stairwell doors have emergency exit signage and corresponding measures, or is a stairwell that will be accessible and can be used at any time? And the architect said the stairwell is separated from the spaces with emergency exit signs and fire rated self-closing doors. So it's an emergency exit stair. It's not used as a means of entrance to the spaces. There's an elevator and another stair within the building that exits on Broadway.
But that stair does not exist.
It doesn't exist, but this is when they came to our landmarks committee this past July for this stairway, which I believe was just approved at the Landmarks Preservation Committee. But landmarks does not care
No.
about use, they just care about the structure.
Yeah.
So, but that coincides with the diagrams that are there is on, and the diagrams are still showing, they're showing a stairway that's not there, so they were done based on some kind of
Did the
plan. Now, whether
architect say when it would be built?
no. But it's just not, so I think we were clear on our concern, and I'll put something in there
Yeah,
to try to, highlight that up at the authority.
right.
Okay, so we deny on that one?
Yeah.
Yes. Okay, and then we have Max Union Square was simply a re-notification. That's an on-premise for a restaurant. We heard it in June 2025. Little Lucky's was a sidewalk cafe. They had one under the old sidewalk cafe program on Lafayette Street. They're closing at 10 p.m. Bleecker Hospitality doing business as possible at 169 Bleecker Street with Roadway. They came in June 2025, closing at 10. They have Stips. 24 Fifth Avenue, Claudette, sidewalk. They've had a sidewalk cafe previously. Closing at 10, got Stips. And Center for Goods, on Howard Street. They're closing at 10. And that does it, so we deny unless on all of those.
On the staircase, can you put in that it's so unknown when the staircase will be built?
Also, I just wish that they would have accommodated us in some sort of agreement, like just verbally, that they follow all the safety, they kind of said that, but it wasn't
They said
very,
it in a vague way.
very vague way. I'm just concerned that this is where,
Yeah.
these are sort of just the vagaries of different things that end up with a unsafe situation.
Well, it's a great matter for agencies don't meet.
Right,
Where
and nobody's talking.
And the community board is the only entities that
It's
look
even
at
in the entirety,
the
yeah.
different things, so I just,
I think Max did, I think
He's a good guy.
I think they're stuck because I think it seems that there are a lot of other problems that they
Yeah.
run into. And for all the saying, oh, we have all these experts, and you don't stop work orders and say,
well, he
you're
could,
not supposed to be building the bar that you're trying to get the temporary license for.
Yeah.
One of the violations is they built the bar without permits on the third floor.
I would imagine that he's hired a bunch of experts. Yeah.
Okay, so wait 1 second, so I just want to end the meeting, we can keep talking, so the one last thing I want to say before we end the meeting.
Yes.
Is if anybody remembers, which you should remember, except for you, Kate, Tulum at 183 Grand Street. That was first a Bobby Karashi, and then it was somebody else. And they, the person was from out of town, the DC area, and he never showed up. and kept never showing up, and I was up with the full board, and I don't know, in March, and they did not get their beer and wine license, they were operating under the temp, they came back to us. Maybe it was in January and they came back to us in March, and anyway, they came back to us in March, we got a stipulation agreement with them. They were supposed to be heard today at the full board, for that, I was gonna go up just to make sure that our stipulation agreement was there, and they withdrew the application on Monday. So I just wanted
A lot of work.
thank the office, I mean, because I will say that from day one, Eva especially did a tremendous amount of back and forth. And following up on everything.
As I recall, there were actually two applications that were competing.
Well, it was Bobby's, and then they came in with Bobby as a partner, with Bobby dropped, he said he no longer had anything to do with it, and then it started with these people,
But
and.
they never actually withdrew the other application, so we had to follow two
Yeah,
in parallel.
Anyway, that's it, adjourn?
Adjourn.
Being adjourned at 8:53.
Early.
Everybody.
Early,
And-
Shirley.